Good evening. So, today we start from where we stopped yesterday in the business law lecture, and we were talking about the corporate or the companies and the company law. And today I am going to discuss with you first of all about derivative actions. Now, what is a derivative action? Derivative action is where a particular company has experienced certain malpractices by its shareholders or the directors. In real sense, it is meant by a lawsuit. A derivative action is a lawsuit. So, a lawsuit brought by a shareholder or a director on behalf of the company. Now, this differs from what we talked yesterday in oppression and mismanagement. Here the difference is that the particular shareholder or the director appears in court on behalf of the company. So, it is not really against the directors or the shareholders or the company, but by appearing on behalf of the company to safeguard the company, it files actions against the conduct of the shareholders or the directors. To enforce or defend a legal right or a claim which the company has failed to do so. So, there is clear demarcation of the action of oppression and mismanagement with a derivative action. Now, how can the court grant relief for an action brought under the company's law? Section 235 is very clear, where it says that the application to be made by either a shareholder or a director on behalf of the company and in the name of the company or its subsidiary or intervening in an ongoing proceedings seeking leave of the court to be first sought out. So, in a derivative action, the particular shareholder or the director who is complaining to the court on a certain mishandling of the affairs of the company should appear with the intention of safeguarding the company itself. So, if I may show you briefly the way of applying for a derivative action in court is where you first of all write in your action that you are appearing on behalf of the company and for the interest of the company, and you are appearing in the name of the company, and thereafter mention the name of the party such as a shareholder or a director who would be the petitioner in this action, and against the shareholders or the directors who are responsible for bringing the company to such fate, which means that you name the particular shareholder, or if there are other parties, shareholder or the directors, you make them the respondents in the action. So, let me again remind you that you are a certain petitioner, either a shareholder or a director, is appearing in the name of the company and on behalf of the company to safeguard the company interests from those who are responsible, such as another shareholder or director or several other parties. Now, this is the very nature of a derivative action, where the law has provided the right of action or to claim for a shareholder or a director who has interest in the company, with the aim and objective of safeguarding this corporate personality. The section 34 is quite clear in the company's law how such an action can be brought in, and in first place the petitioner can ask for a restraining order from the court to restrain these respondents from acting adversely towards the interests of the company. But however, the most important thing that you need to keep in mind is that you cannot file the action and seek relief at first hand, like in the other two areas of oppression and mismanagement, where a derivative action requires firstly to seek the leave of the court to proceed with the action, or the consent of the court to proceed with the action derivative, for you to obtain your final relief. And also the law provides that in order to restrain these respondents from acting negatively further or adversely further against the interests of the company, you may be able to obtain a restraining order against this respondent from so acting. So, derivative action in nature is quite a equitable type of a relief that is given for a shareholder or a director who has an interest of the company, and in that case the court would analyze the situation that take place in this company, and having analyzed, if the court is convinced that such misconducts are being occurring in the company, then would give the leave or the consent to proceed with the action and prove to the court that the court should intervene here and provide the relief by putting an end to these respondents' adverse actions on the company's interests. Now, this particular derivative action came into being as a common law remedy in UK by the case Fosworth versus Harbottle. Now, in this case in 1843, what happened was that Richard Foss and Edward Starkey Turton were two minority shareholders in the Victoria Park Company. The company was to buy 180 acres of land near Manchester, and according to the report, enclosing and planting the same in an ornamental and park-like manner, and erecting houses thereon with attached gardens and pleasure grounds, and selling, letting, or otherwise disposing thereof. The claimants, or rather the shareholders of the company, alleged that some shareholders of the company alleged that the property of the company had been misapplied and it was not used for the purpose it ought to be used, and it therefore wasted, and various mortgages were given improperly over the company's property. That would finally result these other innocent shareholders becoming liable. So for that reason, they went and explained to the court seeking relief in this circumstance. They asked that the guilty parties be held accountable to the company and that a receiver be appointed for the winding up when there was such a violation taking place with those actions of the respondents. Having gone through these facts and issues, the court granted the relief in preventing these respondents from acting negatively towards the company's interests, and this became later on the Foss versus Harbottle rule, a common law rule of a derivative action. But with time and with noting the importance of this common law rule, Foss versus Harbottle, this became a part of the statutory law where the Parliament passed an act recognizing this decision of the court and making it as a statutory rule, so that the derivative actions become part and parcel of the company law statutorily implemented by legislation. Now, I would like to talk about the topic of winding up of companies. Throughout this lecture series, we have been talking about the formation of a company, or rather the incorporation, and thereafter about the shareholders, directors, who are the main players of the company, and then about the various mishandling of affairs that would lead to oppression, mismanagement, and also to take a derivative action in safeguarding the interests of a company. So lastly, I would like to deal with the subject or topic of winding up, because it may have serious effects on the company's existence. I mean, really to say that winding up will conclude the company affairs and put an end to the existence of a company. Now, this is an area which is very important, because as you open a company, you need to know how you can close a company. So winding up is all about that. Generally, in what circumstance a company could be wound up? Especially the winding up by a court. How can a court wind up a company? Under section 270 of the Companies Act, when the company has by special resolution resolved the company be wound up by court, if the company prefers it to be wound up by court, it may take a resolution in the company general meeting to wind up the company by court. The second situation is where the company does not commence its business within a year from its incorporation or the inception that it is registered, or suspend its business for a period of 1 year in between, after the commencement or after the incorporation, then such a company can be wound up. Let me repeat again. since the incorporation of the company, if the company doesn't commence its business activities for a period of 1 year, or while the company was going on for a period of 1 year, the company did not engage in business activities. In either of these circumstances, a company may be wound up. The third way is if the number of members falls below the minimum number required by the company law. Now, I told you at the beginning that a private company requires 2 shareholders at least, and a public company can be incorporated with a 1 shareholder. Now, in case of these 2 companies, if it fails to keep this minimum requirement going through the company's existence, or where the company started with the minimum, but later on certain shareholders resign and letting the company go below the minimum shareholder requirement. So, in that case, the company, such a company will be wound up because it cannot maintain the sufficient minimum number required by the law. Because not only at the inception, but also in the entire existence of the company has to maintain the minimum number of members, the shareholders. So, if it fails to do so, it is a matter that such a company be wound up. The next situation is where the company has no directors appointed. Now, in a previous lecture, I mentioned to you all, along with the company registration document, in order to obtain the certificate of incorporation, the form 1 you are presenting to the registrar of company must indicate the names of the directors of the company. So, in that case, if you fail to give the names to the registrar of companies, the names of the directors, and at certain instance that the existing directors have resigned and there exist no directors at a certain time, then the company cannot exist, because I told you that the company directors are the agents of the company, and they are the people or the persons who are running the company affairs, day-to-day business. When there are no directors, the company simply cannot run. So, therefore, when there are no directors, a company shall be wound up. The next situation is where the company is unable to pay its debts. Now, we saw in Solomon versus Solomon and Company Limited what happened was, Solomon was bankrupt, or rather before bankrupt, basically the company did not have the sufficient assets to pay off the debtors, or the creditors rather, the debt to the creditors. So, that became the reason that the company was wound up. So, the company could not pay its debt. So, when a company comes to such a situation where it is unable to pay its debts, and there is no way that even by selling the assets of the company may not be able to pay off its complete debt burden, then such a company can be wound up or shall be wound up. The last situation is where the court is of the opinion that it is just and equitable to wind up. The existence of the company would bring negative results, and therefore, it is just and equitable. It can be justified that the company's winding up serves the purpose, as well as it is of matters of equity that such a company be wound up. In the opinion of the court, in the opinion of the court. So, the last situation is where in the opinion of the court, it is just and equitable to wind up the company. So, now according to section 270, there are 6 circumstances where a company could be wound up. Now, the next question that comes into our mind is, who have the authority to wind up a company? Firstly, a competent court has the authority to wind up a company. When you say a competent court, it is the court that is vested with the jurisdiction to hear and determine matters arising of company law. So, it is generally the district court or the commercial high court, that may be the situation, that has the power under the company law to wind up a company. Now, in Sri Lanka, we have district courts all over the country, and the district court is generally the most competent court to wind up a company, especially because of the fact that when a particular company becomes insolvent or unable to carry on with its business activities, the district courts of Sri Lanka in various districts and jurisdiction, they have to wind up such companies that have been incorporated and fall into the situations that I previously discussed. Secondly, there could be voluntary winding ups. Now, when you say voluntary winding up, it could be either the shareholders or the creators winding up voluntarily, or that the creditors to whom the company owes debt could voluntarily wind up the company, rather than letting that company go more bankrupt than the situation it has faced at the time of taking the action of a voluntary winding up by the creditors. Now, apart from these voluntary winding up, there also may be that where the court, the competent court, intervenes in a winding up, in a voluntary winding up situation, stating that the court would supervise such voluntary winding up to make sure that the voluntary winding up is properly and smoothly handled. That is a situation where there is a petition by a shareholder, creditor or director that the voluntary winding up is not taking place properly. And if the court determines that yes, it needs a supervision of the court, then the court could interfere and supervise the winding up. Now, this is different from a court mandatorily winds up a company. When a mandatorily winding up by court, the court follows the particular procedure of winding up completely. But in a voluntarily, under the supervision procedure, it only supervises whether the voluntary winding up of the shareholders or creditors is smoothly taking place. Now, let me explain you further on the situation of a winding up by court. According to section 272, it lays out how an application for winding up by court be presented to the court. Here, an application to the court for the winding up of a company shall be by petition, a petitioner who comes and petition the court to wind up a certain company, but the petitioners shall not be less than 2 shareholders. So, at least 2 shareholders need to be there in that application or the petition for a private company, or 1 shareholder with respect to a public company, and that they present the petition subject to this provisions of this particular section of 272 and the other areas covered within this part. And such a application can be brought likewise. This application to the court for winding up either by the company or any creditor or creditors in a case where the shareholders are not going to present such a petition. The company itself can be represented by either a shareholder or a director, or by any creditor or creditors, including any contingent or prospective creditor or creditor to be in a situation where a certain company has a debt, but the way the company is proceeding, a certain person who has given a certain debt to a company see that this company is going into a clash or going into an end or disaster. So, in that case, a prospective creditor that see that can also make such an application, or the contributory or contributories, or by all or any of those parties jointly or separately, they can make an application to the court to wind up the company. Now, when I mentioned about the term contributory, who is a contributory? It could mean a shareholder of the company and every person liable to contribute to the assets of the company, such as paying the share value at the event of a winding up or closure, in the event of being wound up. And for the purpose of all proceedings, for determining and all proceedings prior to the final determination by the court, the persons who are deemed contributories and includes any person alleged to be a contributory. So, there is a wide coverage of persons within the meaning of contributory. Natural persons as well as juridical persons who have shares and interests in the company or debt against the company that the company owes. Under 273, section 273, the hearing of a winding up petition, the court may dismiss it without hearing if the court is satisfied that no, the company is not running into such a scenario that needs winding up, or it may even adjourn the hearing conditionally or unconditionally until such a company anticipating a winding up could still patch up and run smoothly. Or make any interim order or any order that it thinks fit to not to go up to the stage of winding up. But however, the court shall not refuse to make a winding up order on the ground that the assets of the company have been mortgaged to an amount equal to or in excess of those assets of the company, or that the company has no assets. So, those things shall not be grounds for a company, for a court to consider a somewhat forced winding up by the court. How does these actions commence in a winding up by court? Under section 277, where a resolution has been passed by the company for voluntary winding up, the winding up of the company shall be deemed to have commenced at the time of passing such resolution. And also, in any other case, the winding up, if it is not a voluntary winding up, in any other case, the winding up of a company by a court shall be deemed to commence at the time of the presentation of the petition to the court for such a winding up. So, these are the two instances that commence a winding up of a company by court. Now, under section 278, what are the consequences of such a winding up by court? Once the court has taken the decision of a winding up, it will be reported or notified to the registrar of companies, and the registrar shall make a minute thereof in his books relating to the company, and he would take action to strike off the name of that particular company by stating that the particular company has been wound up by court. Now, subsequent to all these things, what would be the effects of such winding up are mentioned in section 280, where it says that the order for winding up of a company shall operate in favor of all creditors. It is in favor of all creditors and of all contributories to the company, and if made on the joint petition of a creditor and of a contributory. If the application had been joined together by a contributory and a creditor, then in that case the winding up would operate in favor of such parties jointly petitioning, or if it is otherwise, the winding up is in favor of all the creditors of the company to safeguard the interests of these creditors to whom the company owes certain debt. Now, in this particular area of forced winding up by courts, the procedure to be followed in this winding up can be summarized in the way I have given it here. Firstly, once the application or the petition has been made to the court for a winding up, the court will appoint an official receiver who will take account of all the company assets and everything, and how are the things that are functioning, and go through all the minutes of the companies and everything. And for that, the official receiver may be appointed on the discretion of the court. This official receiver, if any, should be the one who is attached to the court, who is vested with this action for insolvency purposes. The official receiver attached to the court for insolvency purposes. Or if there is no such official receiver so attached, such person as the minister to whom this particular subject of companies come under may appoint as official receiver to that court. Then such receiver shall submit, he will go through all the details of the company and submit a statement in the prescribed form of the affairs of the company, and he verify them by way of an affidavit where he give the oath as to the contents that he is stating in the statement prescribed form, as to the accuracy of these contents. But he is preparing and showing the particulars of the assets, the debts, the liabilities, the names, residential addresses and occupations of its creditors, the securities held by them respectively, whatever, if there are any secured creditor who has given secured loan facility, such as Solomon in the Solomon versus Solomon and Company Limited case, the dates when the securities were respectively given, and such further or other information as may be prescribed. And the receiver should give this information or the statement in the prescribed form within 14 days from the relevant date. The relevant date being where a provisional liquidator is appointed for this. So, within 14 days from the day that a provisional liquidator has been appointed by the court in respect of this company, or within such extended time as the official receiver may require and request from the court and obtain the consent and approval of the court to extend his time. Thereafter, the court may appoint either a single liquidator or liquidators depending on the circumstance and the nature of the case. And then this liquidator shall take into his custody now, or under his control, all the properties and things in action to which the company is or appear to be entitled. The company assets or remaining things that the company has or is entitled to. The liquidator take over all those things to his custody. Now, thereafter, where a company is being wound up by the court may, on the application of the liquidator by order, direct that all or any part of the property or whatever description belonging to the company or held by trustees on its behalf shall vest in the liquidator by his official name. So that all necessary actions will be taken in respect of these assets by the liquidator himself. Now, for example, if there is outstanding collections to be obtained, or if there is some rents to be obtained, or interest to be obtained from banks, all these things will be vested in the name of the liquidator. And the liquidator will inform all these institutions about the winding up and that he is entitled to take into custody and be held for the assets of the company that is being wound up. Thereafter, as soon as may be after making a winding up order, the court shall settle a list of contributories. The court set down a list of contributories who are entitled for the assets or for the debt or the whatever the remaining assets, with power to rectify the share register in all cases where rectification is required in pursuance of this act, and shall cause the assets of the company to be collected and applied in discharge of its liability. So, whatever remaining assets that there are would be distributed in accordance with the shareholding, and if there are any liabilities, to rank these liabilities accordingly as per the Company Act and distribute those liabilities to the creditors and other parties who owe these amounts. The court may at any time after making a winding up order make an order or any contributory for the time being on the list of contributories to pay in the manner directed by the order any money due from him or from the estate of the person whom he represents to the company, exclusive of any money payable by him or such estate by virtue of any call in pursuance of this act. Thereafter, the court may order any contributory, purchaser or other person from whom money is due to the company to pay the amount due into a specified bank and a bank account or any branch thereof to the account of the liquidator. As I mentioned you, again, it is the liquidator that would hold such money and be accountable to the court. Where the official receiver becomes the liquidator, in case a company, whether provisionally or otherwise, he may, where satisfied that the nature of the estate or business of the company or the interest of the creditors or contributories generally require the appointment of a special manager to manage the remaining assets of the company, other than the receiver. The court may, in the event of the assets being insufficient, if the court finds that the assets are insufficient, then in such a case make an order as to the payment out of the assets of the costs, charges and expenses incurred in the winding up. Where the affairs of a company have been completely wound up following this procedure that I mentioned and all the other connected areas that are mentioned in the Companies Act. The court shall, where the liquidator makes an application in that behalf that the matters are fully settled, then make the final order that the company be dissolved from the date of such order, and the company shall be so dissolved. So now you see, from the time the court takes a decision to wind up the company and up to the time that the company is so dissolved, these steps have to be taken, and finally to close down, to shut down the entire company, and then to inform the registrar to strike off the name from the company register maintained in the country. Now, let us look at the second way of winding up of a company. Now, this is not a type of a forcible winding up. This is what we call the voluntary winding up. Now, voluntary winding up is two-folded. The shareholders winding up and the creditors winding up. But however, the procedures involved in these two types of winding up differ from each other to a certain extent. Not completely though, but to a certain extent. Now let us first concentrate on in what circumstances can a company be voluntarily wound up. Under section 319, there are three instances where such voluntary winding up is possible. First one is when the period, if any, if the company has been set up for a certain period by stating that in the articles of association, they are fixed for the duration of the company by the articles, that the duration expires, then or the event, if any, occurs, or if the articles say that a company being incorporated and set up for us until a certain occurrence occur, then where the articles say so, thereafter either the time has lapsed or the occurrence has occurred, the company could be dissolved. And the company can take this decision to dissolve it through the winding up process at a general meeting where a resolution has been passed to that effect, requiring the company to be wound up. The second situation is where the company resolves by special resolution. It is not a general resolution where things have derived from the articles of association, but where the company itself has resolved by special resolution in its meetings that the company should be dissolved, then the voluntary winding up procedure could take place accordingly. The third situation is where the company resolves by special resolution to the effect that it cannot, by reason of its liabilities, continue its business, and that it is advisable to wind up. So now if you analyze these three instances where voluntary winding up can take place, in the first case, it is by virtue of the operation of the articles of association, where the article of association has specifically mentioned a duration of time that the company would exist, or rather until an occurrence occur. The second situation is where by special resolution the company resolves to be dissolved. Now that could be a situation where a company has attained or company has obtained a certain profit after which the company doesn't want to exist. The shareholders doesn't want to continue with the company. The third situation is where that the company has felt, the shareholders have felt that looking at the liabilities that the company has to meet, it is not worthwhile to continue with the operations of the company, and therefore close down the company affairs. So, voluntary winding up can take place in either of these circumstances. Under section 321, how can such a general voluntary winding up take place or commence? It commences at the time of passing of one of these resolutions that I mentioned to you before for such voluntary winding up. And under section 322, it mentions about the consequences upon winding up. The company shall, from the date of commencement of the winding up, cease to carry on its business, except so far as may be required for the beneficial winding up, and to remain and to keep the status quo intact, and also to keep the powers of the company remain until such dissolution is made. Now, how can such a winding up take place procedurally? The procedure involved in shareholders voluntary winding up and the procedure involved in creditors voluntary winding up, as I mentioned to you before, slightly differ. Let us first focus on the procedure involved in shareholders voluntary winding up. Firstly, the directors of the company may, at a meeting of the directors, upon the request of the shareholders, make a statutory declaration to the effect that they have made a full inquiry into the affairs of the company, and that they are of the opinion that the company will be able to pay its debts in full within 12 months from the date of commencement of winding up. Now, if you look at this first step, you would see that it is necessary to bring the accounts to zero and not minus, not to a loss situation. So, you bring the accounts to break even, and then whatever the profits, if there are any profits of the company, you dispose among the shareholders and then bring the accounts to zero, so that there are no liabilities. But if you cannot bring the accounts to zero, then it means that you cannot go for a voluntary winding up. Then the only way you can is to go for a compulsory winding up by the court or a voluntary winding up by the creditors, either. In this case, since the accounts could be brought to zero, this should be done within the 12 months period from the date of commencement of the winding up procedure for this. The company at a general meeting shall appoint, the company now appoint, not the court. The company may appoint one or more liquidators for the purpose of winding up the affairs and then the distributing of the assets of the company among the shareholders, the contributories, and whoever who owes a debt from the company, such as creditors. Then all these powers of the directors, all the powers of the directors in the direct board of directors shall cease to exist, except so far as the company in general meeting or the liquidator sanctions the continuance until certain matters are finally sought out. Only then for the sorting out of such matters. Thereafter, where the liquidator so appointed and taking everything into his custody at any time of his opinion that the company will not be able to pay its debts in full within the period of 12 months, he shall forthwith summon another meeting of the creditors and inform them and lay before the meeting a statement of the assets and liabilities of the company. Now, that situation may give rise for the creditors to come up with a voluntary winding up. However, in the event the winding up continuing more than 1 year, the liquidator shall summon a general meeting of the company at the end of each such year if it continues further from the date of commencement of the winding up. As soon as the affairs of the company are fully wound up, the liquidator shall make up account of the winding up, showing how the winding up has been conducted in a general meeting called for such purpose. Now, if the liquidator fails to adhere to this procedure as well as to keep the timelines, or failing which to keep the meetings accordingly each year within the time frame, if he fails to do so, if the liquidator fails to do so, he would be liable for the penalty that is mentioned in the Companies Act. Now, as soon as the affairs of the company are fully wound up, the liquidator shall make up an account of the winding up, showing how the winding has been conducted in a general meeting that he calls for such purpose. Thereafter, the liquidator shall send to the registrar of companies a copy of the accounts and shall make a return to him of the holding of the meeting, of its dates and other relevant information that needs to be provided. Thereafter, the registrar, on receiving these accounts and either of the returns, shall forthwith register them, and on the expiration of 3 months from the date of registration of these returns from the liquidator, the company shall be deemed to be dissolved finally. So, these are the steps or procedures taken in regard to a voluntary winding up by the shareholders. So, let us now look at the other side of a voluntary winding up. That is the procedure involved in the creditors' voluntary winding up. The creditors winding up. In that situation, the company shall cause a meeting of the creditors of the company to be summoned for the day on which there is to be held a meeting at which the resolution for voluntary winding up to be proposed. Now, that could be the commencement of the halfway of the shareholders voluntary winding up, where the liquidator has come up with his findings that the accounts cannot be brought to zero. So, in such a case, the creditors can proceed to voluntarily wind up a company under the creditors voluntary winding up procedure. Here then the directors cause a full statement of the position of the company's affairs together with the list of creditors of the company and the estimated amount of their claims against the company assets, remaining assets. The creditors and the company at their respective meetings may nominate a person to be liquidator for the purpose of winding up the affairs and distributing the assets. The creditors at the meeting held may, if they think fit, appoint a committee of inspection consisting of more than 5 persons in addition to the liquidator so appointed. However, the liquidator carrying on his work shall summon a general meeting of the company and a meeting of the creditors at the end of the first year, like in the earlier case, from the commencement of the winding up, and each succeeding year if he is unable to finish off this within 1 year, and shall lay before the meeting an account of his acts and dealings and of the conduct of the winding up during the preceding year. Now, if he fails to do so, the Companies Act has imposed certain penalties against the liquidator for his failure to act accordingly. Now, as soon as the affairs of the company are fully wound up, the liquidator shall make up an account of the winding up, showing how the winding up has been conducted and the property of the company has been disposed of, or the properties rather, and thereupon shall call a general meeting of the company and a meeting of the creditors for the purpose of laying the account before the meetings. Thereupon, the registrar, on receiving the account in respect of each meeting, shall forthwith register them, and on the expiration of 3 months from the date of registration thereof, the company shall be deemed to be dissolved. So, you see, it is very nice and clear that at the end, the registrar, on receiving the account in respect of each meeting, shall forthwith register them, and on the expiration of 3 months from the date of such registration, the company shall be deemed to be dissolved. So, that is the end of the company affairs upon a creditor's voluntary winding up. Now, the last area of a winding up is where the winding up takes place on the supervision of the court. Now, this is not a difference. This is not a different procedure altogether. I have spoken to 3 types of winding ups: the court compulsory winding up, the shareholders voluntary winding up, and the creditors voluntary winding up. Now, in the last 2 scenarios of a voluntary winding up by shareholders or by creditors, an interested party, who is having an interest in the company, may request by petition to the court or petition the court, seeking the supervision and intervention of the court in these procedures that they take place with regard to these voluntary winding ups. So, in what circumstances a company be wound up? Subject to supervision of the court. Under section 351, when a company has passed a resolution for voluntary winding up, the court may make an order that such voluntary winding up shall continue, but subject to such supervision of the court and with such liberty for creditors, contributories and or others to apply to the court of any mishandling of the affairs, perhaps, and generally on such terms and conditions as the court thinks fit. Under section 353, a winding up subject to the supervision of the court shall be deemed to be a winding up by court. So, when the intervention of the court has been petitioned and requested by a party, then the court supervision in the voluntary winding up procedure that we discussed before would mean the same as a court making a winding up of a company. Now, let us look at the procedure involved in such winding up. Now, since the voluntary winding up procedures are taking place, as I mentioned before, the court will only make an order appoint an additional liquidator to support the liquidator who has been already put to the job under the shareholders winding up or under the creditors winding up. So, the court appointed liquidator would be a co-liquidator who would support the already appointed liquidator. And thereafter, the court follow the same procedure as the voluntary winding up, and from time to time when the court summon the liquidator to inform the court of the procedures and steps taken, the court will take the subsequent steps and inform the liquidators there will inform the court of the subsequent steps that they have taken, and thereafter inform the court of such steps taken, and also where the liquidators finally dissolve the company, as I mentioned to you in the voluntary winding up procedure, they will, the liquidators will inform the court that they have done it in this way, the proper way, and then the company has been dissolved accordingly. So, that is simply the winding up procedure of the companies, and from here onwards I would like to discuss few model questions with you for the benefit of checking your knowledge on the area of company law or rather business law in your syllabus pertaining to corporations. And on the next day, I would like to concentrate on past questions relating to this area, and I will be discussing about certain questions that have come up in your past papers of this subject for the benefit of all the students. Let me first of all take this model question 1. Now, you see here the promoters of a hotel company entered into a contract, the promoters, which means they naturally a pre-incorporation contract on its behalf for the purchase of wine. When the company formally came into existence, the company ratified the pre-incorporation contract. The wine was consumed, but before the payment was made, the company went into liquidation. The promoters as agents were sued on the contract. So, now the question here is discuss the legal basis of this dispute. Now, you would see that the company at the time the promoters had purchased the wine in the name of the company had not been in existence. It is yet to be formed. So, therefore, these types of contracts are called pre-incorporation contracts. Now, in such a scenario, the validity of such a contract matters. But what happened was that after the company was incorporated, the company ratified, the directors ratified that pre-incorporation contract of purchasing the wine. But however, before the payment was made to the seller of the wine by the promoters, the company ran into liquidation. That it bankrupt and ran into liquidation. Then a matter came up that the company is not liable to pay those creditors, the buying suppliers, because the pre-incorporation contract was not valid in law. This is exactly what happened in the case of the Kellner versus Baxter in 1866. And in this case, the court decided, yes, the pre-incorporation contracts, though ratified later on by the company upon incorporation, would not be valid, and therefore the company would not be liable to pay the suppliers or the creditors. Now, the common law decision was prevalent for a very long time in these regards. But now, our company law has very specifically accepted and recognized the pre-incorporation contracts, and that these pre-incorporation contracts, what the promoters enter into prior to an incorporation of a company, are still valid in law. So, the common law situation in Kellner versus Baxter has now been replaced by statutory law in Sri Lanka, that the pre-incorporation contracts that later on been ratified obtains proper validity. But however, if the particular contract has not been ratified by the company later on, then there will be no validity of this contract. So, this is how you need to argue in such a question that you receive, supported by the proper authorities. Under question 2, the Articles of Association forms the sole constitutional document of a company under the New Companies Act. Therefore, it must be ensured that the business of a specific company must be conducted strictly for the objects as set out in the Articles of Association. It raises the question, do you agree with the statement? First of all, where you need to say an answer whether yes or no, and thereafter discuss reasons for your conclusion. Now, let us go back to the statement to see whether we can say yes or no. The Articles of Association forms the sole constitutional document of a company under the New Companies Act. Therefore, it must be ensured that the business of a specific company must be conducted strictly for the objects as set out in the Articles of Association. Do you agree with this statement? Yes, it is. Because the very nature of doing an Article of Association, being the constitution of the company needs to be abide by and operate within those parameters of the company articles. So, you cannot go beyond the articles. Now, this is what we call, if you go beyond the articles, it raises the concerns of acts of ultra vires. I have explained to you this previously. So, the case of Ashbury Railway Carriage Company versus Rishikesh is a classic example of this, that a company need to stick to the Articles of Association. But however, if the Articles of Association are quite general, where a company can do all and sundry matters of business affairs, that gives a much bigger scope for them to work within. But if the Articles of Association has specified the objects for which the company has been constituted, incorporated, then the company must work within these parameters and then execute the business affairs. So, this is what you have been asked to discuss in this question. In question 3, Sarath is a shareholder of 123 Private Limited, a company registered under the company law of Sri Lanka. Recently, Sarath has noted that the business affairs of 123 Private Limited are being conducted in a manner which Sarath considered to be questionable. Specifically, he feels that his rights as a shareholder are being severely prejudiced by this conduct. Sarath seeks your advice. Explain in detail as to what rights he possesses against the company and the board of directors of the company in this regard. Now, when you go back to the question, it states that the business affairs of 123 Private Limited are being conducted in a manner which Sarath considers to be questionable. Specifically, he feels that his rights as a shareholder are being severely prejudiced by this conduct. Now, this is a typical oppression and mismanagement situation, where the affairs of the directors have been prejudicial on Sarath, and Sarath feels, it says, his rights as a shareholder are being severely prejudiced by this conduct. Now, this is not an action of a derivative action that you can take, because it says in this question that specifically he feels that his rights as shareholder are being severely prejudiced. It is not that he wants to protect the company interest, but he wants to protect his rights and entitlements in the company. Now, in case Sarath wanted to, having seen this, that there is some acts of prejudice happening to the interest of the company, then he would have come under the derivative action procedure in the name and for the interest of the company. So, you need to analyze your answer in such a way that it explains specifically what are the remedies that Sarath has in this regard. In question 4, Newfoundland Enterprises Private Limited is a company which was incorporated in the year 2008 and has been involved in the business of importing and selling automobiles. However, due to the recent fluctuation in the automobile industry, NF has been facing grave financial problems, and in this context, the shareholders and creditors of the company are concerned about the company's ability to meet its liabilities. All parties concerned are considering winding up of the company. In this context, the parties concerned have forwarded the following queries to be addressed in relation to the winding up of a company. So, what you are asked to deal with is explain as to what is meant by winding up of a company. What we discussed today in analyzing what is winding up, how winding up processes can be done by court, by voluntary, and then if voluntary, then under supervision. You need to analyze your answer, what is meant by winding up of a company. Winding up of a company is simply bringing the company affairs to a closure, and that leads finally to a dissolution of the company and strike the name of the company and its affairs from the registrar of companies. List the types of winding up available for the company. Like we discussed, there can be compulsory winding up, voluntary winding up of shareholders and creditors. But in this case, there is no way that the court would go for a compulsory winding up. because it's the shareholders and creditors have felt that the company was not running well. So obviously, it will have to go for a voluntary winding up either by shareholders or creditors or jointly. However, if the accounts cannot be brought to zero in this company, then you cannot go for a voluntary winding up by the shareholders. You will have to go for a voluntary winding up by creditors. Since it says that the company's ability to meet its liabilities are of a concern, and they are also having grave financial problems, it appears to be that the accounts cannot be brought to zero. So obviously, in such a manner, this situation would end up in a creditor's voluntary winding up. So lastly, it has asked to outline the key difference between a voluntary winding up and a compulsory winding up. Now, voluntary winding up is where the shareholders or the creditors have the opinion of a voluntary winding up, rather than where the court is compulsorily winding up on the basis that the company is creating prejudice to its own, and that for the sake of the company and maybe for the sake of whoever who have liabilities against the company, be better off if a compulsory winding up and consequent dissolution take place. So I believe that you all have understood how to answer these questions, how to analyze, how to go through them, and so forth. I will be doing the question and answer session next day based on the past papers and past paper questions that have come up during the last few years in this subject of business law. So thank you for listening, and I believe that my lectures have served the purpose of educating these students as well as enabling them to learn more precisely on the subject area. And thank you very much for listening.